Thanks to all who have joined us by WebEx for standing by. Welcome to the open meeting of the Public Company Accounting Oversight Board. During the meeting, you'll be in listen-only mode. As a reminder, this meeting is being recorded and a recording is expected to be made available on the PCAOB website. I would now like to turn to Chair Williams to formally convene the meeting.
Thank you, Phoebe. Good morning and welcome, everyone. This is an open meeting of the Public Company Accounting Oversight Board on June 6, 2023. We welcome those of you who have joined us today by webcast or dialing into the teleconference. Before we proceed with the agenda, I will note for the record that all board members are participating in this meeting and we are able to hear one another. The only order of business before the board today is a staff recommendation that the board propose for public comment amendments to its auditing standards relating to the auditor's responsibility for non-compliance with laws and regulations, including fraud in the performance of an audit. To present the staff's recommendation, I will turn to our Office of the Chief Auditor, Barb Vantage.
Good morning, Chair Williams and board members Disparte, Ho, Stein, and Thompson. The Office of the Chief Auditor is pleased to recommend that the board issue for public comment a proposal on the auditor's responsibility for consideration of a company's noncompliance with laws and regulations, including fraud, when performing an audit. The proposal would replace the standard related to illegal acts by clients, as well as amend other related PCAOB standards. Highly publicized matters have drawn attention to the role of the auditor in detecting violations of laws and regulations, including, among other things, those related to consumer or environmental protection. We have observed that companies' noncompliance with laws and regulations may lead to sanctions, material fines, and civil settlements, resulting in substantial damage to investors through falling share prices, especially when noncompliance has occurred, gone undetected, or the related impact is not properly addressed in the financial statements. This proposal seeks to better protect investors from the resulting harm when the effect of noncompliance that has a material effect on the financial statements goes undetected. In addition, today's recommendation aligns with the board's strategic plan to modernize existing standards. Existing AS 2405 was adopted by the PCAOB in 2003 based on a standard issued by the AICPA in 1988. The existing standard predates the enactment of federal securities law provisions that fundamentally alter the auditor's responsibilities for detecting and responding to illegal acts, namely Section 10 Cap A of the Securities Exchange Act. Additionally, the Sarbanes-Oxley Act included provisions related to corporate governance, among others, that have led companies to develop sophisticated ethics and compliance systems. We've considered these changes in developing our proposed requirements that would apply to all audits performed under PCAOB standards. We believe that the proposal in front of you strengthens investor protection by enhancing the auditor's responsibility for the identification, evaluation, and communication of noncompliance with laws and regulations. Auditors have a fundamental obligation to protect investors through the preparation and issuance of informative, accurate, and independent auditor's reports. Auditors plan and perform the audit to obtain reasonable assurance that the company's financial statements are free of material misstatement, whether due to error or fraud. Some laws and regulations relate to the manner in which matters are presented in the financial statements, while others may relate to the operations of a company. With respect to all laws or regulations, misstatements of the financial statements can arise when violations occur and are not presented, that is, recorded or disclosed in the financial statements. Current AS 2405 states that the auditor's responsibility to detect and report misstatements resulting from an illegal act having a direct and material effect on the determination of financial statement amounts is the same as that for misstatements caused by error or fraud. The current standard has few requirements related to the auditor's identification of noncompliance with other laws and regulations that have a more indirect relationship with the financial statements. One key aspect of the proposal is the removal of this direct-indirect distinction. The proposal in front of you would require the auditor to identify those laws and regulations with which noncompliance could reasonably result in a material effect on the financial statements without regard to whether that effect could be viewed as direct or indirect. As my colleagues will describe in more detail, we are recommending to establish and strengthen requirements for identifying laws and regulations with which noncompliance could reasonably have a material effect on the financial statements, assessing and responding to the risk of material misstatement arising from noncompliance with laws and regulations, identifying whether there is information indicating noncompliance has or may have occurred, and evaluating and communicating when the auditor identifies or otherwise becomes aware of information indicating that noncompliance with laws and regulations, including fraud, has or may have occurred. I would like to acknowledge the many people within the PCAOB who made a significant contribution to this project. First, I would like to express my sincere appreciation to the team that led this project: Jessica Watts, Lisa Calandrillo, Kevin Lombardi, and Michael Szymanski from the Office of the Chief Auditor, along with Rebecca Mealy from the Division of Enforcement and Investigations, as well as our other colleagues in OCA who provided support on this project. Additionally, I would like to thank our colleagues from other offices for their significant contributions, in particular Michael Gerbit and Tian Liang and John Cook in the Office of Economic and Risk Analysis, and Michael Unger and Connor Rasso in the Office of General Counsel. I would also like to recognize the support provided by staff from the Division of Registration and Inspections, the Division of Enforcement Investigations, and the Office of Communications and Engagement. Finally, I would like to thank the Securities and Exchange Commission staff, including the staff of the SEC's Office of the Chief Accountant, for their support and timely assistance with this project. Lisa Calandrillo and Rebecca Mealy will now provide an overview of the proposal, and then Tian Ling of the Office of Economic and Risk Analysis will provide some additional remarks, followed by our recommendation. Lisa?
Thank you, Barb. Good morning, Chair Williams and board members. I'd like to start today by saying a few words about the proposed meaning of noncompliance with laws and regulations. We are recommending to replace the term illegal acts with noncompliance with laws and regulations. As with the existing definition of illegal acts, the proposed meaning of noncompliance with laws and regulations is broad and encompasses any act or omission, intentional or unintentional, by the company whose financial statements are under audit, or by its employees or others that act in a company capacity or on the company's behalf that violates any law or any rule or regulation having the force of law. Noncompliance with laws and regulations includes fraud, as described in paragraph 5 of AS 2401, consideration of fraud in a financial statement audit. That is an intentional act that results in a material misstatement in the financial statements that are the subject of an audit. Noncompliance with laws and regulations does not include personal conduct by the company's personnel unrelated to the business activities of the company. The proposed definition encompasses a wide variety of conduct, including embezzlement of company funds, misappropriation of assets, or the payment of bribes, as well as other conduct that has financial consequences to the company, such as violations of employment, occupational safety and health, antitrust, and privacy laws and regulations. And consistent with the existing standard, noncompliance with laws and regulations would not include personal conduct unrelated to company business. The new term would focus the auditor on all types of noncompliance, whether the violations concern financial or operational issues, or involve intentional or unintentional conduct. Another important point to note here is that the proposed definition of noncompliance with laws and regulations would expressly include fraud, as described in PCAOB standards. Importantly, while the PCAOB standard related to an auditor's consideration of fraud in a financial statement audit would continue to govern the auditor's responsibilities with respect to the identification of information that may be indicative of fraud, the evaluation and communication of fraud would be addressed by the proposed standard. And those requirements would be applied in the same manner as for other forms of noncompliance with laws and regulations. The proposal also sets forth clear objectives for the auditor. As Barb noted, auditors have a fundamental obligation to identify and evaluate information related to noncompliance with laws and regulations that has or may have occurred. The proposed objectives align with this fundamental obligation and would create requirements for the auditor to identify laws and regulations with which noncompliance could reasonably have a material effect on the financial statements, assess and respond to the risk of material misstatement of the financial statements due to noncompliance with those laws and regulations with which noncompliance could reasonably have a material effect on the financial statements, identify whether there are instances of compliance with laws and regulations that have or may have occurred, and when the auditor identifies or otherwise becomes aware of information indicating that instances of noncompliance have or may have occurred, evaluate and communicate instances of noncompliance with laws and regulations that have or may have occurred, regardless of whether the effect of the noncompliance is perceived to be material. I'll briefly discuss the first three objectives and the related proposed requirements. First, the proposal would strengthen current requirements by establishing an unconditional responsibility for the auditor to plan and perform procedures to identify laws and regulations with which noncompliance could reasonably have a material effect on the financial statements. The phrase "could reasonably have a material effect," as used here, enables auditors to tailor their planned procedures to focus on those laws and regulations that relate to the way matters are presented in the financial statements and other laws and regulations that may relate to the operations of a company with which the company's noncompliance could reasonably result in material penalties, fines, or damages. These laws and regulations would necessarily be relevant to the company or its operations, but would not represent every law or regulation to which the company is subject. Next, upon identifying laws and regulations with which noncompliance could reasonably have a material effect on the financial statements, we are recommending requiring the auditor to plan and perform procedures to assess and respond to the risk of material misstatement of the financial statements due to noncompliance with those identified laws and regulations. To facilitate this identification, the proposal includes enhanced risk assessment requirements for auditors to obtain an understanding of the regulatory environment. That includes a proposed description of the nature of the laws and regulations auditors would understand as part of the audit. In addition to the procedures for obtaining an understanding of the regulatory environment, we are recommending more specific procedures that include obtaining an understanding of management's processes related to preventing, identifying, investigating, evaluating, communicating, and remediating instances of noncompliance with laws and regulations. Also, the processes for receiving and responding to tips and complaints from internal and external parties regarding noncompliance, including those received through any whistleblower program that exists, and the process for evaluating potential accounting and disclosure implications of noncompliance regulations. We are also recommending making and evaluating inquiries to management, the audit committee, internal audit personnel, and others who might be reasonably expected to have relevant information. These inquiries and other procedures complement the existing risk assessment requirements. These inquiries would focus on instances or alleged or suspected instances of noncompliance with those laws and regulations for which noncompliance could reasonably have a material effect on the financial statements. The proposed inquiries would inform the auditor's initial assessment of risks of material misstatement, including risks due to noncompliance, and are similar to the inquiries in the existing illegal acts by client auditing standard. The proposal integrates the new and enhanced requirements into the existing risk assessment standards to underscore that noncompliance could affect the risk of material misstatement of a company's financial statements, and to help avoid any misperception that the auditor's consideration of noncompliance exists in a silo or should be performed as a discrete step in an audit. The performance of the enhanced risk assessment procedures would also inform the auditor's understanding of how noncompliance could have a material effect on the financial statements and enable the auditor to assess and respond to the related risks of material misstatement. In addition to these enhanced risk assessment procedures related to consideration of noncompliance with laws and regulations, we're also recommending certain amendments that are intended to generally enhance the auditor's risk assessment procedures that we believe would have broader benefits to the audit, such as requiring the auditor to read publicly available information about the company, including information made available by the company and other sources external to the company, as well as information publicly disclosed by the company's executive officers about the company. The proposal's third objective is for auditors to identify whether there is information indicating noncompliance with those laws and regulations with which noncompliance could reasonably result in a material effect on the financial statements has or may have occurred. Our recommendation would require auditors to plan and perform procedures to identify whether there is such information indicating noncompliance. Under this approach, the nature and extent of procedures that the auditor would plan and perform to identify whether there is information indicating noncompliance has or may have occurred would depend on the specific facts and circumstances of each audit engagement. The population of laws and regulations for which the auditor would plan and perform such procedures would be those the auditor reasonably have a material effect on the financial statements. As part of planning and performing such procedures, the proposed amendments would require auditors to use information obtained from their risk assessment procedures, including the enhanced procedures included in the proposed amendments, and from other procedures performed in the course of the audit of the financial statements, reviews of interim financial information, and, if applicable, the audit of internal controls over financial reporting to identify information indicating noncompliance has or may have occurred. As the risk of material misstatement increases, the persuasiveness of the evidence the auditor would be required to obtain from these procedures also increases. The amendments would underscore that the process for identifying information indicating noncompliance has or may have occurred is not a discrete process, but again, is integrated throughout the audit, and that at any point during the audit, the auditor may identify or otherwise become aware of information indicating noncompliance with laws and regulations has or may have occurred. Now I'd like to hand it over to Rebecca, who will discuss the proposal's fourth objective, to evaluate and communicate noncompliance that has or may have occurred, as well as reporting considerations and other proposed changes. Rebecca?
Good morning, Chair Williams and board members. Picking up where Lisa left off, when the auditor has identified or otherwise becomes aware of information indicating that noncompliance with laws and regulations, including fraud, has or may have occurred, we are recommending that the auditor evaluate and communicate such instances, regardless of whether the effect of the noncompliance is perceived to be material to the financial statements. These procedures for evaluating and communicating information indicating noncompliance with laws or regulations has or may have occurred would apply equally to all information indicating noncompliance with laws and regulations, including instances of fraud that has or may have occurred. For purposes of evaluating information indicating noncompliance with laws and regulations, the proposal sets forth requirements for the auditor to obtain an understanding of the nature and circumstances of any such noncompliance and determine whether it is likely that any such noncompliance occurred. The proposal establishes a threshold for evaluating noncompliance with laws and regulations that is similar to the threshold for evaluation that currently exists in Section 10A, that requires evaluation when a firm detects or otherwise becomes aware of information indicating that an illegal act has or may have occurred, whether or not perceived to have a material effect on the financial statements of the issuer. Under the proposal, the extent of the procedures necessary would depend on the nature and circumstances of the matter, including whether the matter could be material, the relevance and reliability of information provided by the company about the matter, and the effectiveness of management's process for investigating the matter. While the auditor can apply judgment to determine the nature and extent of procedures to evaluate information indicating noncompliance has or may have occurred and may include inquiries in their procedures, the proposal notes that inquiries alone would not be sufficient to determine that noncompliance did not occur, or that is, was unlikely. The proposal does acknowledge, however, that inquiries alone may be sufficient to determine that likely noncompliance has occurred. Once the auditor determines a matter is likely noncompliance, the auditor would be required to determine the possible effects on the financial statements and the implications of such likely noncompliance on other aspects of the audit. The proposed standard provides a list of factors relevant to the auditor's determination of the possible effect of the likely noncompliance on the financial statements. These factors are the materiality of the likely noncompliance, the effect on the amounts and disclosures in the financial statements, including potential contingent monetary effects, such as fines, penalties, damages, or provisions for allowances or returns, and the adequacy of any financial statement disclosure. The proposal would also add a requirement for the auditor to perform additional procedures as necessary to determine whether the likely noncompliance results in other information in documents containing audited financial statements or the manner of its presentation being materially inconsistent with information appearing in the financial statements or containing a material misstatement of fact. The proposal recognizes that some likely noncompliance may have an impact on other information accompanying the audited financial statements and reminds auditors that they have an obligation with respect to other information under PCAOB standards. Additionally, the proposal would require the auditor to assess the implications of likely noncompliance on other aspects of the audit and take appropriate action. For example, the auditor may identify new risks of misstatement in a particular account or disclosure that are based on the identified likely noncompliance, for which the auditor may need to design and perform additional audit responses. In the event that the auditor determines the likely noncompliance has a material effect on the financial statements, the proposal includes a requirement to evaluate the timeliness and appropriateness of management's remedial action. There may be instances where remedial actions are ongoing or only planned at the time the auditor is expected to issue the audit report. In such circumstances, it is expected that the auditor would determine if the actions taken up until the time of the report issuance are appropriate and whether the auditor's standard report is required to be modified. In an integrated audit, the auditor would also consider the effect of such ongoing or planned remedial actions on the effectiveness of internal controls over financial reporting. As noted earlier, we are also recommending enhancements to the auditor's communications to management and the audit committee related to noncompliance upon becoming aware that noncompliance has or may have occurred, as well as after the auditor evaluates the potential noncompliance. When the auditor identifies information indicating that noncompliance with laws and regulations, whether or not perceived to have a material effect on the financial statements, including fraud, has or may have occurred, The proposal would require the auditor to, as soon as practicable and before the issuance of the engagement report, communicate the auditor's understanding of the nature of the matter and the circumstances of its occurrence to the appropriate level of management, as well as the audit committee, unless the matter is clearly inconsequential. We believe a communication takes place as soon as practicable when it is made in sufficient time to allow the recipient to use the information to take necessary actions. Additionally, if the auditor determined the matter is likely noncompliance, the auditor would communicate the possible effect of the noncompliance on the financial statements and other information in documents containing the audited financial statements. In certain circumstances, the proposed standard allows auditors to limit their communications to management and the audit committee to reduce redundant communications. After the auditor has completed the evaluation of the information indicating noncompliance has or may have occurred, the proposal would require the auditor to communicate to management and the audit committee, unless the matter is clearly inconsequential, the results of the auditor's evaluation, including which of the matters were determined to be likely noncompliance, and for each instance of likely noncompliance, whether it has a material effect on the financial statements. Our proposal would also require the auditor to determine the effect of any likely noncompliance on the engagement report and the ongoing relationship with the company. We believe that audit participants, including other auditors and auditor specialists, may be the first engagement team members to become aware of fraud or other noncompliance. These participants would be in the best position to bring such noncompliance to the attention of the auditor. Therefore, we are recommending specific coordinated procedures and communications concerning noncompliance when auditor specialists or other auditors participate in the audit. These proposed requirements would address two-way communication between the lead auditor and the other auditors or auditor specialists, and would improve the auditor's consideration of a company's potential noncompliance with laws and regulations. Now I would like to provide a brief overview of a few other proposed changes. The proposal in front of you also includes amendments to other PCAOB standards that relate to noncompliance with laws and regulations. We are recommending a requirement for the auditor to evaluate implications for the audit when transactions or relationships with a related party indicate noncompliance has or may have occurred, regardless of whether the company disclosed such transactions or relationships to the auditor or not. We are also recommending amendments to the standard on reviews of interim financial information that would provide specific procedures, including additional inquiries related to potential noncompliance. That concludes my remarks. Thank you for your time and attention. I will now turn the floor over to Tien to provide some additional remarks, followed by our recommendation. After that, we would be happy to respond to any questions you may have.
Thank you, Rebecca. Good morning, Chair Williams and board members. Staff of the Office of Economic and Risk Analysis, or OERA, have performed an economic analysis of the proposed standard and other amendments that OCA staff have just outlined for you today. Our economic analysis, as always, includes establishing a baseline of firm performance under today's standards, identifying a need for standard setting, evaluating the likely economic effects of the proposed standard, and assessing reasonable alternatives. As part of establishing the baseline, OERA staff analyzed relevant academic literature. That literature shows that corporate noncompliance can result in significant legal and regulatory penalties, as well as reputational loss, causing substantial financial damage to companies and investors. However, our economic analysis also shows that auditors may not have sufficient incentives to identify, evaluate, and communicate a company's noncompliance. Studies further suggest that auditors have not, in fact, played a primary role in detecting noncompliance, and anecdotal evidence indicates that stakeholders expect auditors to play a larger role. The proposed amendments would strengthen the auditor's incentives to identify noncompliance with laws and regulations that reasonably could have a material effect on the financial statements by providing clearer, stronger regulatory accountability. Overall, the proposed requirements should benefit investors by reducing the likelihood that financial statements are materially misstated due to the effects of noncompliance. They should also lead to more timely intervention by companies to remedy noncompliance, which should in turn reduce the investor harm caused by billions of dollars in legal and regulatory penalties, as well as the associated reputational loss suffered by companies and investors annually. At the audit engagement level, the magnitude of the benefits is likely to be affected by the risk of noncompliance and by the degree to which issuers have already implemented their own formalized compliance programs. Our economic analysis also recognizes that the new requirements would likely result in additional, potentially substantial costs to auditors and the companies they audit. Auditors would incur certain fixed costs to implement the proposed amendments. These include costs to update audit methodologies and tools, and to prepare training materials and conduct training. In addition, auditors would be expected to incur engagement level variable costs. These costs could be substantial. For example, auditors may expend considerable additional audit effort, including the involvement of numerous specialists to identify relevant laws and regulations, to assess and respond to the risk of material misstatement, and to identify whether there is information indicating noncompliance with those laws and regulations has or may have occurred. The magnitude of these costs likely will depend on the extent to which existing practice differs from the new requirements, the nature of the company and its operations, and the related regulatory environment. Companies being audited may also incur costs related to the proposed amendments, both directly and indirectly. For example, companies may pay additional audit fees and may have to spend more time supporting the auditor performing the audit. Companies may also seek to mitigate the extent of the auditor's additional substantive procedures by enhancing the company's own processes and controls over its compliance with relevant laws and regulations, both so as to provide the auditor a better starting place for its analysis, and so that there is less noncompliance for the auditor to identify. In closing, I would like to thank our colleagues in the Office of the Chief Auditor and the Office of the General Counsel at the PCAOB and our friends at the SEC for their collaboration in the development of our economic analysis. With that, I'd like to hand it back to Barb to present the staff's recommendation.
Thank you. In closing, the staff is recommending that the board issue for public comment a proposal related to the auditor's responsibilities when the auditor becomes aware of information indicating non-compliance with laws and regulations and related amendments to board standards substantially in the form provided to you. Thank you. And with that, we're happy to respond to questions.
Thank you, Barb, Lisa, Rebecca, and Tian. At this time, my fellow board members and I will have an opportunity to make a statement or ask questions to the staff. We will proceed in the order of seniority, and I will begin. Today, we are continuing to pursue our investor protection mandate by proposing amendments to AS 2405, currently titled The Legal Acts by Clients and Related Standards. A company's non-compliance with laws and regulations, including fraud, can have devastating consequences for investors. When sanctions, fines, and civil settlements directly affect a company's bottom line, or reputational damage causes a company's stock value to decline, innocent investors pay a price. Unfortunately, there are no shortage of examples. Well-publicized issues relating to Wells Fargo offer just one. Last month, Wells Fargo agreed to pay $1 billion to settle a class action lawsuit from investors alleging it made misleading statements about compliance with consent orders imposed by federal regulators. A lawyer for those investors underscored just who gets hurt when these incidents happen, saying the settlement would, quote, help compensate hundreds of thousands of investors, state employees, nurses, teachers, police, firefighters, and others whose critical retirement savings were impacted by Wells Fargo's fraudulent business practices. Those very same investors are who we are here to protect, and that's what we are doing today with this proposal. When an auditor signs an audit opinion on a company's financial statements, saying they are signing their name to the fact that the financial statements, quote, present fairly in all material respects the company's financial position and results of operations, investors expect that all means all, including material respects impacted by noncompliance. Unfortunately, the current standard on illegal acts fails to meet that expectation. In fact, it says an audit in accordance with PCAOB's auditing standards does not include audit procedures specifically designed to detect all illegal acts that could have a material effect on the financial statements. Today, we are proposing to change that and ensure that the protection investors expect, the protection they deserve, matches the requirements in the standard. The proposed standard AS 2405 accompanies noncompliance with laws and regulations, strengthens the requirements for auditors to identify, evaluate, and communicate information that may indicate a company's noncompliance with laws and regulations. First, identify. The proposed standard requires the auditor to perform procedures to identify the laws and regulations with which noncompliance could reasonably have a material effect on the company's financial statements during their initial risk assessment. Consistent with performing risk assessment procedures, the proposed amendments would require the auditor to assess and respond to risk of material misstatements of the financial statements due to noncompliance with those laws and regulations, including identifying information indicating potential noncompliance. For example, the auditor would be required to inquire of management whether correspondence exists with the company's relevant regulatory authorities regarding instances or alleged or suspected instances of fraud or other noncompliance with laws and regulations, and if so, the nature of that correspondence. While the current standard could be interpreted to understand that the auditor has limited responsibilities with respect to noncompliance with certain laws and regulations, unless they happen to stumble across information, the new standard makes clear what investors already expect, that it is the auditor's responsibility to proactively be on guard for all noncompliance that may have a material impact on the financial statements. I want to be clear. This does not mean auditors are required to know every single law or regulation on the books. In fact, the proposal itself clearly states, quote, these laws and regulations would necessarily be relevant to the company or its operations, but would not represent every law or regulation to which the company is subject. Other PCAOB standards already require auditors to have adequate technical training and proficiency to conduct an audit, which includes a basic understanding of a company's regulatory environment. And the companies themselves know the laws and regulations they must follow and which ones pose the greatest risks, because they have to include such risks to comply with certain disclosure requirements. So the laws and regulations for which noncompliance could reasonably have a material effect on a company's financial statements is readily available to the auditor. Next, evaluate. The proposed standard includes enhanced procedures related to how the auditor must evaluate information once they become aware that noncompliance with laws or regulations has or may have occurred. Specifically, the proposed standard provides additional direction by requiring the auditor to consider whether specialized skill or knowledge is needed to assist the auditor as part of the evaluation. The existing standard only requires the auditor to consult with legal counsel or other specialists if management does not provide satisfactory information that there has been no illegal act. The proposal includes the requirement for the auditor to consider whether specialized skill or knowledge is needed because legal counsel or other specialists can provide valuable assistance to the auditor's evaluation. Requiring auditors to contemplate whether use of experts is needed is a common practice across PCAOB standards, including when performing risk assessments, planning or performing audit procedures, and when evaluating audit results. So this proposal is not requiring anything out of the ordinary for auditors. Finally, communicate. Problems can't be fixed unless they are known. The existing standard merely requires the auditor to communicate to the audit committee illegal acts that come to the auditor's attention as soon as practicable and prior to the issuance of the auditor's report. The proposed standard enhances communication by requiring the auditor to communicate to the audit committee in at least two specific instances. First, upon becoming aware of information indicating that noncompliance has or may have occurred, and then again after the auditor has evaluated such information. This would provide greater interaction between the auditor and management and the audit committee, with the goal of encouraging companies to take quick action to come into compliance and reduce investor harm caused by legal and regulatory penalties. The PCAOB has grappled with the need to strengthen AS 2405 for nearly 2 decades. I strongly believe now is the time to move this standard forward and invite everyone to help us bring this long overdue project to a conclusion for the benefit of investors. I look forward to the additional feedback we will receive during the comment period, and I encourage all to comment. I would like to thank the individuals that have significantly contributed to this proposal. Specifically, I would like to thank in the Office of the Chief Auditor, Barb Vantage, Jessica Watts, Lisa Colandrello, Kevin Lombardi, and Michael Szymanski. In the Office of the Economic Risk Analysis, Mike Gerbett, Tian Lang, Federico Garcia, and John Cook. In the Division of Enforcement and Investigations, Rebecca Mealy, and in the Office of General Counsel, James Capoli, Connor Rasso, and Michael Unger. I would also like to express my gratitude to my fellow board members and their staff for their contributions to this proposal. In addition, I would like to recognize the support provided by the staff from the Division of Registration and Inspections, the Division of Enforcement and Investigations, and the Office of Communications and Engagement. Finally, I would like to thank the Securities and Exchange Commission staff, including the staff of the SEC's Office of the Chief Accountant, for their support and assistance. The current standard was adopted by the PCAOB in April 2003, based on a standard issued by the Auditing Standards Board of the American Institute of Certified Public Accountants in 1988. In the 35 years since 1988, we've seen far too many examples of investors getting hurt due to non-compliance with laws and regulations. We've seen changes in the federal securities laws, and we've heard calls from investors for auditors to live up to their responsibilities to ensure financial statements are presented fairly in all material respects. It's time we answer those calls. I will now turn to my fellow board members for any statements they may wish to make or questions they would like to pose to the staff. Board Member Disparti, the floor is yours.
Good morning, Chair Williams. Good morning, everyone. I want to join Chair Williams in expressing my deep appreciation to the staff for their expertise and efforts in developing today's proposal, including spending substantial time with me and my team throughout the process. The auditor's responsibility is to plan and perform procedures to obtain reasonable assurance about whether the financial statements are free of material misstatement, whether caused by error or fraud. As with any transaction or event, a company's non-compliance with laws or regulations or the existence of fraud, collectively I'll refer to that as non-compliance, may have implications for recorded amounts and disclosures in the financial statements and for internal controls over financial reporting. It is therefore essential and important that our standards, in conjunction with the requirements of Section 10 Cap A of the Securities Exchange Act, sufficiently and clearly address the auditor's responsibilities with respect to noncompliance. As I will further explain, though, I am unable to support today's proposal, as I believe it unreasonably and at great cost expands the scope of the audit to incorporate extensive new compliance attestation procedures, and that this will require legal acumen and expertise well beyond the auditor's core competency. Staff's economic analysis highlights the significant harm that fraud and other noncompliance has sometimes inflicted on companies, investors, employees, and others across society. The analysis also concludes today's proposal is likely to significantly increase audit effort and cost across virtually all firms and audits, and thus on preparers and investors. What is less clear is whether some of the increased requirements are appropriate for the auditor in the context of the auditor's expertise and the objectives of a financial statement audit. Many of today's proposed enhancements are positive. For example, today's proposal, as you've heard, would strengthen requirements during risk assessment and throughout the entire audit to identify, assess, and respond to risks of material financial statement misstatement associated with noncompliance. The requirement for the auditor to plan and perform procedures to address risks of material misstatement from noncompliance, regardless of whether the related law or regulation has a direct or indirect effect on the financial statements, also makes sense relative to the auditor's financial statement audit responsibilities. However, this expanded scope raises concerns when coupled with the additional proposed requirement for auditors to, quote, plan and perform procedures to identify whether there is information indicating noncompliance. This wording suggests the auditor would be expected and held accountable to identify any and all information that might indicate instances of noncompliance of any law or regulation across the company's operations without regard to materiality. In my view, this is a significant scope expansion, and to meet this requirement, auditors would be required to embed compliance attestation procedures into the financial statement audit. This is well beyond both the scope of the financial statement audit and the auditor's core competency, and will trigger the need at great cost to significantly increase the use of lawyers and other specialists on many, if not all, PCAOB audit engagements on a recurring basis. The scope of the expanded auditor's procedures cannot be underestimated. Companies of all sizes are subject to a vast array of laws and regulations with which they must comply. That includes federal, state, and local laws in each domestic and in each foreign jurisdiction in which they operate. These laws and regulations continually evolve and cover a myriad of areas, including corporate governance, securities, markets, trade, contracts, taxes, consumer, employment, health, safety, environmental, privacy, intellectual property, mergers, acquisitions, foreign corrupt practices, among many others. The applicability and significance of each law will change as the company's business changes, and each law or regulation may have different effects on different business units or divisions. I acknowledge and understand that the proposal focuses the auditor on those laws and regulations with which noncompliance could reasonably have a material effect on the financial statements. While that is true, the filtering threshold of reasonably could is not adequately explained in the proposal and is not addressed elsewhere in PCAOB standards. For example, it is unclear whether auditors would make this likelihood assessment considering management compliance policies, programs, processes, and controls, that is, in other words, consider risk on a residual basis, or would management be required, or I'm sorry, the auditor be required to consider risk on an inherent risk basis. In any case, lawyers will be required across the wide array of legal disciplines and specializations to assist the auditor in identifying the population of relevant laws and regulations, assess this could reasonably scoping filter, design and perform procedures to identify information that may indicate potential noncompliance, and evaluate whether such noncompliance has or has likely occurred. Other provisions of the proposal with which I have concern include, for one, it is unclear whether the concept of reasonable assurance is applicable to the auditor's identification of instances of noncompliance or information indicating noncompliance. Reasonable assurance should certainly apply. It seems that the proposal may be establishing a requirement beyond existing requirements in AS 2710, other information in documents containing audited financial statements. This additional requirement would be for auditors to validate whether management has appropriately disclosed information on noncompliance outside the audited financial statements. It is also questionable whether it would be useful or a distraction to the audit committee for the auditor to communicate information indicating potential noncompliance prior to the auditor's evaluation of whether the noncompliance has likely occurred or the evaluation of any financial statement impacts. Stepping back, this project is one of 14 on our ambitious standard-setting agenda, and each of the projects is significant. As we proceed one by one, I am increasingly concerned that we are establishing new auditor obligations and incrementally imposing new auditor responsibilities in ways that will significantly expand the scope and cost of audits and fundamentally alter the role of auditors without a full and transparent vetting of the implications, including a comprehensive understanding of the overall cost-benefit ramifications. I also wonder whether we are further contributing to the expectations gap by imposing responsibilities on auditors that are not aligned with their core competencies or the fundamental purpose of a financial statement audit. I hope commenters will consider and respond to the concerns that I have raised, as well as provide additional perspectives to further inform my thinking and the full board's deliberations. In addition to investors and auditors, input from audit committees, corporate governance experts, preparers, and academics would be particularly helpful. I would like to recognize and thank the staff from across the PCAOB's divisions and offices who have contributed to today's proposal, especially Barb Vantage, Jessica Watts, Lisa Calandriello, Kevin Lombardi, and Michael Szymanski in the Office of the Chief Auditor, Rebecca Mealy in the Division of Enforcement and Investigations, Mike Gerbett, John Cook, Kian Liang, and Federico Garcia in the Office of Economic and Risk Analysis, and Connor Rasso and Michael Unger in the Office of the General Counsel. I also thank Chair Williams for her leadership and my other fellow board members and each of their staffs. I thank Brent Seimer, Katie Driscoll, and Lucia Caramba from my team, and the staff from the SEC's Office of the Chief Accountant for their collaboration and sharing of perspectives on the project. With that, I turn it back to you, Chair Williams.
Thank you. Board Member Ho, the floor is yours.
Thank you, Chair Williams. Having spent most of my career in some form of public service at the federal and state level, the PCAOB's mission as a nonprofit corporation to protect investors and further the public interest is important to me. Congress had the foresight to require in Section 101 of the Sarbanes-Oxley Act of 2002 that 2, but only 2, of the 5 PCAOB board members be certified public accountants. This 2 CPA requirement was included as a concession to Senator Enzi, who graduated college with a degree in accounting. Senator Enzi explained that setting auditing standards is complicated and detailed and requires the knowledge and expertise of individuals who understand and have worked in the field of accounting. As one of the CPA board members, I therefore take this responsibility very seriously. I critically review each standard proposed by the PCAOB through 2 different but complementary lenses. First, will the proposed standard enhance investor protection? Second, will the proposed standard promote trust in our capital markets overall? Specifically, to promote trust in capital markets, in my opinion, we need a resilient and transparent audit marketplace with competent experts and a sustainable accountability system. I was supportive of the board strengthening our existing standard related to auditors' consideration of possible noncompliance with laws and regulations. Unfortunately, the proposed standards before the board today contain a breathtaking expansion of the auditor's responsibilities, which I believe will hurt investors. This expansion could cause considerable confusion on the appropriate role of auditors, undermine the time-tested accountability framework, and reduce the resilience of the already highly concentrated audit marketplace. Ultimately, this could undermine trust in our capital markets to the detriment of investors. Specifically, I have three significant concerns. First, the proposal is not fully transparent about the significant additional responsibilities it would impose on all public company auditors by eliminating the distinction between non-compliance that has a direct versus indirect effect on a public company's financial statements. Proposed AS 2405, paragraph 5A, would require auditors to identify the laws and regulations with which non-compliance could reasonably have a material effect on the financial statements of the public companies being audited. The preamble to the proposal refers to the phrase could reasonably have a material effect as an appropriate tailoring, noting that it focuses the auditor's attention on laws and regulations that could have a material effect on the financial statements. At first blush, the proposed requirement seems reasonably tailored. However, this is where having auditing experience makes a palpable difference in understanding the proposal's potential impact on auditor responsibilities. To identify the laws and regulations with which non-compliance could reasonably have a material effect on financial statements, an auditor must first identify all the laws and regulations applicable to the public company. It is this threshold requirement which causes me the greatest concern and for which the proposal does not seem to fully address. For example, although the proposal includes a sentence that the requirement, quote, would not represent every law or regulation to which the company is subject, unquote, in two places of the preamble to the proposal, it appears to be inconsistent with our existing auditing standards. Moreover, in a bit of understatement, the economic analysis explains that auditors would likely need to expend considerable additional audit effort to identify relevant laws and regulations under the proposed standard, and that the costs associated with the proposed amendments may be substantial. Second, the proposal introduces ambiguities regarding auditor obligations to investors by transforming the auditor's role from one of providing reasonable assurance to one of performing a management function. The securities laws and their implementing regulations do not require a public company's management to identify all laws and regulations that the public company is subject to. And this proposal seeks to fill that void by requiring auditors to do so. This approach could undermine the long-established accountability framework whereby management prepares and discloses financial information. Auditors provide an independent certification on the disclosures, and regulators provide oversight of the public companies and auditors. This accountability framework has been established since 1934 and is part of the bedrock of the trusts built in our capital markets. The preamble downplays this by stating that the auditor would be able to benefit from management's process to identify certain laws and regulations as it pertains to, for example, SEC Regulation SK disclosure requirements regarding material risks. However, the SEC currently does not require reasonable assurance on this disclosure, and our proposal will essentially require auditors to provide reasonable assurance on this disclosure by first identifying all laws and regulations the public company is subject to, consistent with existing PCAOB standards. Specifically, PCAOB Auditing Standard 1105, paragraph 10, generally provides that when using information produced by the company, the auditor is presumptively required to perform procedures to test the accuracy and completeness of the information. Third, the proposal takes a one-size-fits-all approach and does not take into account differences between large auditing firms on the one hand and mid-sized and smaller firms on the other hand. Auditors are CPAs, not legal experts. The new requirements will significantly expand auditors' need for expertise from lawyers, legal experts, and possibly other specialists, resulting in a substantial increase in audit fees. The economic analysis acknowledges that the proposal would have a greater cost impact on non-affiliated firms, which are generally mid-sized and smaller firms. I'm concerned that the proposal will create additional barriers to entry. Investors in the auditing profession can ill afford these barriers, given that the audit market for large multinational public companies is limited to roughly a handful of firms capable of performing such engagements. This significant expansion of auditor responsibilities could therefore further reduce competition and exacerbate the power concentration in the audit marketplace. As Senator Enzi noted, setting auditing standards is complicated and detailed. Our standards therefore must be clear, thoughtful, fair, and underpinned by a deliberate, transparent, and inclusive process. Although I am critical of some of the key requirements in this proposal, I am keenly interested in commenters' views on this proposal, especially in response to questions 7, 8, 11, 59, 60, 62, and 63 on whether the expansion of the scope to include indirect noncompliance is clear and reasonable, and whether the completeness assertion is reasonably achievable without significantly increasing the audit fees. In conclusion, and for the reasons stated above, I cannot support this proposal. I value the opportunity to share my views today, and I look forward to learning other perspectives, as healthy debate is the foundation of our democracy. These are not easy problems to solve, so we need to work together to develop the optimal solution, and I'm committed to doing so. As American philosopher Eric Hoffer said, the beginning of thought is in disagreement, not only with others, but also with ourselves. Finally, I want to express my gratitude to the Office of the Chair, Office of the Chief Auditor, Office of Economic and Risk Analysis for the time they spent discussing this proposal with my office. Special thanks go to Lisa Calandrello for her hard work on this important project. Thank you also to staff in the Office of General Counsel, the Division of Registration and Inspections, and the Division of Enforcement and Investigations for their contribution. Thank you. Back to you, Chair Williams.
Thank you. Board Member Stein, the floor is yours.
Thank you, Chair Williams. Today, the board is considering a staff recommendation to replace the current interim standard on the auditor's role in detecting and reporting potential illegal acts. As mentioned before, the current interim standard, AS 2405, became part of the board's interim standards in 2003 when the board absorbed the generally accepted auditing standards of the AICPA. So interestingly, the current interim standard was originally drafted in 1977 and last revised in 1988. It does not take into account fully a series of unfortunate events, including the failure of more than 745 financial institutions during the savings and loan crisis, the numbers game and earnings management problems of the 1990s, the seeming prevalence of accounting fraud that included the misdeeds of Enron and WorldCom and Adelphia and Tyco, matched with over 900 corrections or restatements of financial reports, or the collapse and/or rescue of 9 major financial institutions in 2007 and 2008, including Lehman Brothers, that sparked a global financial crisis. Further, the current standard does not reflect the passage of the Sarbanes-Oxley Act, which created a new framework for corporate responsibility and, importantly, and I would say fundamentally, changed the audit-issuer relationship. Congress also established a new era of investor protection through the creation of the Public Company Accounting Oversight Board. It gave the PCAOB the drafting pen for audit standards, with instructions to protect investors and to further the public interest in the preparation of informative, accurate, and independent audit reports. The proposed standard we are considering today is at the heart of the board's mission. It covers ground that Congress intended us to cover when it enacted Sarbanes-Oxley. For hundreds of years, the practice of auditing has embodied a public trust. The auditor's report on the cost of the Greek Parthenon was actually chiseled on a marble column of the Acropolis. The Roman Senate would conduct a hearing of account when one auditor succeeded another. And in fact, the word audit is derived from the Romans' practice of hearing of account, the Latin word adire. The essential qualities of an auditor have endured the centuries. One of the first auditing manuals in the United States described the functions of an auditor plainly. The lawyer's duty is first of all to the client, but the public accountant has only one duty to the client and to the public. One duty: to tell the truth, the whole truth, and nothing but the truth. That was written over a century ago, and it's still true today. Interestingly, the congressional response to the Great Depression had to take into account a growing population of investors, and it included some new ideas: a framework for regulation by disclosure and a reliance on independent third-party auditors. The proposal for the government to employ a corps of government auditors for the veracity of company reports was what Congress had in the draft legislation that ultimately became the 34 Act. But this was unseated by the accounting profession. Colonel Carter, one of the most influential and recognized leaders of the accounting profession at the time, testified before the United States Senate committee. A vision of independent third-party auditors rather than using government auditors to make sure that public companies were accurately, giving us an account of their financial statements. So this concept was incorporated into the new securities laws so as to afford even greater protection for investors. Even after the financial crisis, one senator, Senator Jack Reed, stated in a Senate hearing, this function of the auditor gives rise to a special responsibility, not a unique or sole responsibility, but a special responsibility, a public trust. So auditing, like any profession, has evolved over the centuries to meet the changing environment, but with one particular important constant: a public trust. Our action today reflects continued recognition of the auditor's public trust. Today, the board considers a staff recommendation for a new standard that, if adopted, would clarify the auditor's responsibilities for identifying, evaluating, and reporting potential illegal acts known as noncompliance with laws and regulations, or NOCLAR. The staff's proposal modernizes the standard in an elegant way, strengthening the critical thinking of the auditor. The approach that the staff has taken is straightforward. The auditor's duty to detect material misstatements should also include detection of non-compliance with laws and regulations, including fraud. Such an approach clarifies the auditor's responsibility to identify material misstatements in a company's financial statements, whether due to error or due to fraud or due to NOCLAR. The staff has developed a standard that incorporates the PCAOB's current risk assessment framework to maximize and empower auditors' professional skepticism and judgment in approaching NOCLAR. Auditors already consider applicable legal and regulatory frameworks when conducting an audit, but the current standard does not require the auditor to plan or perform audit procedures. Normally, an audit in accordance with generally accepted audit standards does not include audit procedures designed to detect legal acts. So the auditor's report is the only means of communication to the investor, and an opinion of fair presentation in all material respects is basically a green light for reliance. But that currently comes with what I would call an embedded hidden caveat. There may be material misstatements due to non-compliance with laws and regulations, which the auditor does not have the responsibility to find. Under today's proposal, the auditors focus on possible material misstatements of the financial statements. That's going to be the focus, regardless of anticipated effect. This should remove the hidden caveat. I'm also pleased that the staff has recommended that the board propose a new presumption that an audit in accordance with PCAOB standards should include audit procedures designed to detect non-compliance with laws and regulations, including fraud. The staff's recommendation simplifies and strengthens the auditor's responsibility in a conceptually sound manner. Under the proposal, the auditor's duty to detect material misstatements is the same, whether due to error, non-compliance with laws and regulations, or fraud. I'm also pleased that the staff's recommendation has eliminated the outdated and I would say hard to justify categorization of illegal acts into direct and indirect buckets. Both auditors and investors agree that this current judgmental splitting of laws into categories of so-called direct and indirect effects on financial statements is a source of confusion. The primary purpose of this categorization was to bifurcate the auditor's duty to identify and assess illegal acts, and particularly rejecting any responsibility for the detection of so-called indirect effect laws. However, staff research has indicated that laws considered to have indirect effects on the financial statements, such as the prohibition of bribery of foreign officials by domestic companies, or evasion of anti-money laundering statutes and protocols, or false and misleading disclosures, or environmental contamination, amongst others, can and have led to substantial fines and penalties. And that may be part of the problem. The parsing of laws and regulations may have caused a lack of emphasis or a diminution of attention to certain laws and regulations. So I'm pleased that the current proposal before us simplifies the auditor's work by removing this distinction. The auditor must do sufficient work to be reasonably assured against material errors of either commission or omission. when companies collapse nearly overnight, or when years of intentional acts of noncompliance are revealed, calls for where were the auditors can always be heard. For example, as our chair mentioned, many of us remember the scandal of bank employees at Wells Fargo creating millions of phony accounts to meet outlandish sales and incentive targets. The conduct was unabated for years. When the scandal became known, the company lost $7.8 billion in stock valuation. The company's auditor told United States senators who are questioning the accounting that the potential impact of the unethical and illegal conduct would likely be insignificant. Moreover, the auditor noted, quote, improper sales practices do not implicate the effectiveness of internal controls, as not every illegal act has a meaningful impact on a company's financial statements or its system of internal controls over financial reporting, end quote. However, the bank paid a high price, as did its investors. The company settled a number of federal enforcement actions, which included a deferred prosecution agreement related to criminal offenses, administrative cease and desist proceedings finding violations of the anti-fraud provisions of the federal securities laws, another administrative proceeding with findings of unfair or abusive practices, and payment of over nearly $5 billion in monetary sanctions. Several former executives have also settled federal charges, including fraud. When the bank confirmed the improper sales practice misconduct in 2016, as the value of its stock decreased by $7.8 billion. Recently, the bank agreed to settle the related shareholder lawsuit for $1 billion. And that's going to help compensate hundreds of thousands of investors, state employees, nurses, teachers, police, firefighters, and others whose critical retirement savings were impacted by Wells Fargo's fraudulent business practices. Today's proposal, if adopted, would make it clear that NOCLAR should not be dismissed by the auditor because management's aware of the matter or because the effects on the financial statements are not direct effects. I'm especially pleased that the first paragraph in today's proposed standard makes it clear that a PCAOB registered auditor has a fundamental obligation to investor that includes, 1, identifying and evaluating information indicating that non-compliance with laws and regulations, including fraud, has or may have occurred, and 2, making appropriate communications to management and the audit committee about such information. The staff has designed the proposed standard to reduce the risk of an auditor failing to detect a material misstatement in a number of ways. First, the standard requires the auditor to apply an iterative risk assessment process that includes information sources external to the company. The improved risk assessment should result in the identification of additional risks, if they're present, for which the auditor is responsible for designing and implementing an audit response. Second, since 1988, companies have focused on strengthening the control environment. And because of the Committee of Sponsoring Organizations of the Treadway Commission, an integrated framework that includes a company's values. The proposed standard replaces an auditor needing to merely understand the control environment with the requirement that the auditor evaluate and obtain evidence of effectiveness. Third, the staff's recommendation also includes new required communications by the public auditor to the audit committee. Over the last 35 years, audit committees have become increasingly involved in the oversight of the financial reporting process and of the external auditor due to the provisions of the Sarbanes-Oxley Act, requiring the designation of a financial expert and the addition of independent directors. Audit committees are often now involved in areas of significant risk. This includes emerging risk, cybersecurity, as well as enterprise risk management. Finally, there have been dramatic changes in the financial reporting and the auditing environment since the standard was first written in the 1970s. The digital revolution continues to revolutionize business. Gone are the filing cabinets and the document storage rooms. Gone are the fax machines. A collection of computer servers provides almost limitless data storage, data analytics, nearly instantaneous communications, such as email, virtual video meetings, and e-documents, and new tools like ChatGPT. Technology in both corporate reporting and in the audit provides an unprecedented opportunity for automated tools, techniques, and visualizations of transactions and events. Technology will provide auditors with a new lens into the fraud triangle. Today, audit firms are using technological tools to perform full population testing, search for anomalies, and discover relationships and patterns because of their ability to ingest increasingly granular data. One global network firm noted, quote, companies have never been as data rich as they are today, providing new opportunities to detect material frauds through data mining, analysis, and interpretation, end of quote. Another global audit network firm said it is using, quote, a revolutionary bot that uses AI and machine learning to x-ray a business, analyzing billions of data points in milliseconds, seeing what humans can't, and applying judgment to detect anomalies in the general ledger. It examines every uploaded transaction, every user, every amount, and every account to find unusual transactions, indicating potential error or fraud in the general ledger without bias or variability. End of quote. Technological tools such as these can increase analysis and forensics, and through machine learning, identify exceptional behavior in contacts or other processes. The continued strengthening and testing of the effectiveness of internal controls over financial reporting also provides the auditor with additional information and more opportunities to uncover non-compliance activity, including fraud. Appropriately, today's staff recommendation does not require a PCAOB registered auditor to perform a compliance audit. Some audit firms advise companies on how to establish world-class ethics and compliance programs to ensure compliance with laws and regulations. However, when an audit firm is conducting an audit, the auditor's role is simply to provide reasonable assurance, not absolute assurance, that the financial statements are free of material misstatement. Consequently, I believe that this proposed standard, if adopted, will provide a right-sized approach to increase the likelihood that auditors will identify NOCLAR that is material to the financial statements by integrating NOCLAR into the umbrella of risk assessment, by considering the information the company is publishing, as well as the information about the company that is generated outside of the company, and by using a holistic approach to challenge management instead of cordoning off potential sources of misstatements. There are 65 questions in the proposal before us today, and I'm particularly interested in, I'm interested in all comments, but I'm particularly interested in answers to some of the following questions. Are the proposed audit procedures sufficiently clear? Should the procedures include digital forensics? Are there others? Are the proposed auditor communication requirements sufficiently clear? Should there be others? To whom should the communications be made? What should be included? Are there auditor reporting considerations or additional requirements that should be made? What is the consideration or requirement and why? And then finally, are there additional requirements that should be made for interim or quarterly reviews. Like my fellow board members, I want to acknowledge the hard work of the very dedicated team that worked on this project. In particular, Lisa Calandriello. I would say she's unmatched in both her work ethic and in her constant patience with my team. I also want to thank Jessica Watts, Kevin Lombardi, and Michael Szymanski from the Office of the Chief Auditor. From the Division of Enforcement Investigations, Rebecca Mealy. From the Office of the General Counsel, Connor Rasso, Michael Unger. And from the Office of Economic and Risk Analysis, John Cook, Tian Liang, and Federico Garcia. In conclusion, the staff's recommendation for a proposal for a new auditing standard is a reduction in complexity and a return to first principles. It holds true to the basic precepts of auditing that were set forth so aptly by Richard Montgomery over 100 years ago. The auditor's responsibility is to detect noncompliance or questionable acts that the exercise of professional skill and care would normally uncover. I'm also reminded what a plain-spoken federal judge once wrote. Quote, surely investors would consider the involvement of officers of a company in complex and wide-ranging schemes to inflate the company's income to be material, even if the scheme had not yielded substantial results, end of quote. And that's precisely the point. The standard we are proposing today is a great step forward for auditor responsibility and empowerment, and for the protection of investors and the markets. I'm pleased to be able to support it, and I look forward to the public's comments. Thank you.
Thank you. Board Member Thompson, the floor is yours.
Thank you, Chair Williams. I support issuing the staff proposal, which would strengthen the requirements of auditors to identify, evaluate, and communicate noncompliance with laws and regulations, including fraud. Our investor protection mission drives this proposal. Indeed, researchers estimate that only 1/3 of corporate frauds are detected, and that such fraud erased $830 billion in equity value during 2021 alone. Another study notes that auditors only detected 4% of cases involving occupational noncompliance. This is simply unacceptable. While auditors may not be the perpetrator of the noncompliance or fraud, auditors are investors, boots on the ground, and are therefore important gatekeepers. Auditors must step up and fulfill their duties. This duty includes planning and conducting an audit that provides reasonable assurance that the financial statements are free from material misstatement where they are caused by error or fraud, and the evaluation of materiality involves both quantitative and qualitative considerations. Auditors have long been required under Section 10 Cap A of the Securities and Exchange Act to perform procedures designed to provide reasonable assurance of detecting illegal acts that could have direct and material impact on the financial statements. Under our proposed standard, mere compliance with 10 Cap A is the floor. We expect more. If adopted, the proposed standard would certainly demand more by requiring auditors to plan and perform procedures to, 1, identify laws and regulations which noncompliance could reasonably have a material impact, either direct or indirect, on the financial statements. 2, assess and respond to risk of material misstatement due to noncompliance with those identified laws and regulations. And 3, identify whether there is information indicating noncompliance with laws and regulations that has or may have occurred. Mere inquiry would not be sufficient to determine that noncompliance has not occurred. Auditors, however, are not required to know every single law or regulation a company may be subject to. In fact, the proposal itself clearly states these laws and regulations would necessarily be relevant to the company or its operations, but would not represent every law or regulation to which the company is subject. Moreover, auditors do not start from a blank slate. The auditor benefits from management's process to identify these laws and regulations. Issuers currently identify and disclose material risks related to laws and regulations and periodic filings made under the federal security laws. The auditor's identification, however, will not be limited to those laws and regulations identified by management to fulfill its disclosure obligation. The list developed by management of such laws and regulations is a source of information for the auditor. In addition, auditors should already have knowledge of a company's regulatory environment as required under existing PCAOB standards, including risk assessment. I believe that the proposed standard appropriately focuses the auditor's attention on only those laws and regulations that could reasonably have a material effect on the financial statements. In doing so, we believe the standard will promote audit quality by ensuring that auditors identify, assess, and respond to material noncompliance, and in so doing, the standard promotes investor protection. The proposed standard acknowledges that there may be times auditors need to engage outside experts. Requiring auditors to contemplate whether use of experts is needed is a common practice across PCAOB standards, including when performing risk assessments, planning or performing audit procedures, and when evaluating audit results. This isn't new or different. I support this proposal for another reason. The current standard was adopted by the PCAOB in April 2003. That standard was issued by the Auditing Standards Board of the American Institute of Certified Public Accounts in 1988. Much has changed since that time. It's critical our standards change and evolve to remain fit for purpose. The auditing profession today and the public issuers and registered broker-dealers we regulate are not what they were in the 1980s. The risk profile of these issuers and broker-dealers have evolved significantly over the last 4 to 5 decades. Many are global companies operating in multiple jurisdictions for which material noncompliance with laws and regulations can go undetected if auditors fail to properly identify, assess, and respond to regulatory and legal risk in the audit. This proposal updates the requirement to reflect today's dynamic market. In fact, that today's vote potentially is not unanimous underscores the importance of our public notice and comment process. While I believe this proposal strengthens requirements on the auditor to identify, evaluate, and communicate noncompliance, the standard can only improve with the benefit of our stakeholders' comments. Today's proposal, if adopted, represents significant change. I therefore encourage all of our stakeholders to provide their feedback. Auditors play an essential role in protecting investors by ferreting out potential noncompliance, evaluating it, and ultimately shining a light on what they discover. Trust in our capital markets depends on auditors performing this role with the due care and professional skepticism it demands. I believe the proposed standard, if adopted, will increase investor protection by raising the requirements of auditors and demanding that they live up to their duty to the investing public. I would like to thank the many individuals involved in this proposal, including from the Office of Chief Auditor, Barb Banich, Jessica Watts, Lisa Caladrillo, Kevin Lombardi, Michael Chemaski, from the Divisions of Enforcement and Investigations, Rebecca Mealy, from the Office of Economic and Risk Analysis, Mike Gerbett, John Cook, Tan Ling, and Federico Garcia, from the Office of General Counsel, Connor Rasso, and Michael Unger. I would also like to thank my fellow board members and my staff for their efforts towards this standard-setting project. Finally, I would like to thank the Securities and Exchange Commission staff, including the staff of the SEC's Office of Chief Accountant, for their support and assistance. Thank you.
Thank you. Unless there are any further discussions from the board, I would now call for a vote on the staff recommendation. Board Member Disparti.
Nay.
Thank you. Board Member Ho.
Oppose.
Thank you. Board Member Stein.
Yes.
Thank you. Board Member Thompson.
Yes.
Thank you. I also vote yes. The recommendation is approved with board members Disparti and Ho dissenting. I want to thank all board members for their input on the proposal and PCAOB staff for your hard work. I look forward to hearing from stakeholders and continuing to work together as we move this proposal forward. That concludes the PCAOB's open meeting for today. As there is no further business, the meeting is now adjourned. Thank you for your participation. You may now disconnect from the webcast and teleconference.